What's a family limited partnership and should you even use one? Hi, I'm John Strohmeyer with Strohmeyer Law. We get a lot of questions from clients who think that if they just set up that family limited partnership, they can erase their tax bill and squash all those dreaded creditors who are out there ready to pounce on them. Unfortunately, it's not going to be that easy. So let's start at the beginning. What is a family limited partnership? At the outset, family limited partnership is really just a partnership structure that has family members as its partners. There's no special magic to it. Here in Texas, we're going to go down to the Texas Secretary of State, file some paperwork, and automatically we have a new partnership. Now, we can pick who we want to be those partners, and that gives us a lot of flexibility. So at the outset, let's just start thinking about what does this structure look like? So here we are. Here's one way of setting it up. What you see is we've got John Ardo as our general partner. He owns a 1% general partnership interest. John Ardo also has created 99% of those partnership interests that he holds for himself. There's the Doe Family Limited Partnership. It's got a bank account and some brokerage assets. What you see, John has created all of this for himself. He owns 100% of the interest in this company or in this family limited partnership. What you see is that John owns 100% of the partnership interests in this family limited partnership. This would be no different than if he had gone down the street, asked one of his friends to be a partner, and then they set up a regular limited partnership without that family moniker. So that could look something like this, where John Ardo is still the 1% general partner. He owns 49.5% of the regular partnership interests. And then here I've listed it at family members, but it could be his business partner owns the other 49.5%. What should we be looking at here? One, that general partner is going to be the person who is in control of that partnership. They're going to be able to do things like make day to day management decisions and affect changes for the business. It will be the person who is in charge. The downside of being the general partner is you have general liability. That means that while the limited partners, John Ardo at 49.5% and the family members at 49.5%, they have limited liability. But the general partner retains general liability. So if the partnership gets sued, the liability is going to fall on that general partner. When you contrast this structure with a traditional limited liability company or LLC, all the members in an LLC will have limited liability by virtue of how it is set up. So that's something to think about. Do you want somebody having general liability? Because if you're doing this to defeat your creditors, you've left somebody out in the cold exposed to creditors. That's the general partner. Now, some people will say, oh, instead of an individual as a general partner, you'll put in a limited liability company or LLC as that general partner, and then we're shutting down liability there. Yes, you could do that. That's one more entity to kind of perpetuate a bigger structure. So, what you've got is a way to own and manage assets. So, is a family limited partnership right for you? Here are 5 myths that you may have heard that we need to address before making sure this is the right structure for you. Myth number one: the family limited partner structure can stop creditors from taking your stuff. First, let's go back to the chart and take a look at how this is structured. So, if we just assume that John Doe has created this family limited partnership where he owns 100% of the interests, what will happen if there's a lawsuit? Well, let's think that there's something that happened down here. There's a lawsuit against these assets. We've got a brokerage account, but what if instead of a brokerage account, we had rental property? So there's liability potential here in this rental property. What could happen? Well, tenant could fall and break their ankle. They could have something happen to them as a result of poor maintenance. They're going to sue this limited partnership. All right, well, great. You say this partnership is where all of the liability stops. The reality is that the lawyer who brings this lawsuit isn't just going to sue the partnership. They're also going to sue the partners. But John, there's limited liability for limited partners. Yes, but what you don't hear is that John Ardo here is still the owner. So in reality, this is what the structure looks like. It's not just these partnership interests, but John Ardo is here at the top. he's the one who owns these interests. And if he gets sued in his individual capacity up here at the top, then instead of trying to take the assets that are owned by the partnership, that creditor, the person who's suing, then that creditor is just going to take this partnership interest. This isn't going to stop any creditors. All it's going to do is slow them down momentarily while they take the partnership interest. So when you look at it that way, how much creditor protection are you getting if you own 100% of that entity? The answer is not much. Okay, well, John, what if we structured it in a different way? Here's that other way that we can think about structuring it. We're going to give things away to other family members. Now, that's where this comes in. We've got these other family members who own 49.5% of the entity. Well, if John gets sued, they can't take this partnership interest that belongs to the family members. Then they can't take over, they can't do things. Okay, well, that may work. But again, you have to be making real gifts. The reason that this type of planning is suggested, and it does work occasionally, is because there's something called charging order protection. What this says is that the partnership or a limited liability company doesn't have to make any distributions to anybody if it doesn't want to. That's controlled by the general partner or manager in the case of a limited liability company. This will stop a creditor from taking anything more than what they would get as a distribution from the partnership. The good news about the way that partnership tax law works is that creditor is going to have the income that should be distributed to them, even if it's not. It's treated as though it's distributed to them for income tax purposes. So, that creditor, they've got this partnership interest, they also get a tax bill, but nothing to pay the tax with. This is protection. This is a good thing. Where the real problem comes in is that you'll get a lot of bad advice and bad suggestions about how to set this up. Looking at these partnership interests, these actually have to be given to somebody else. And if there are assets down here in the partnership, those need to be reported probably as gifts to the family members. Reporting gifts means that you've implicated the estate and gift tax system. Have you done that? A lot of times when I talk to prospective clients about this, they haven't been told about the potential gift tax effects of transferring partnership interests. That's problem number one. Problem number two with this potential strategy is I've also heard that people will say, well, we'll give this away in name only, but we'll have some paperwork that says, no, family member, you're going to hold on to this for outward appearances, but in reality, this still all belongs to me. Okay, do you honestly think that's going to hold up in a court of law? Having a side agreement where you've given something to somebody, but really it's just yours still, that's not going to survive discovery. This is going to be when the lawsuit comes, you're going to have to expose the background documentation about these entities and who actually owns it. So, this is a nonsense strategy that people shouldn't be falling for. If somebody's saying, oh, we're just going to have this done on paper, but in reality it's another way, that's a huge warning flag. So if you hear somebody suggesting that you have one thing on paper and another in reality, this should be a gigantic red flag for you in going forward with that planning. So, yes, family limited partnerships can address some creditor issues, but it's not some cure all that's going to defeat every creditor every time, and especially if you haven't done the background work to make sure it will actually work. Our next myth: having a family limited partnership can lower your income tax bill. Okay, going back to our structure. Here we are. We've got all of the income that's being generated down here in the partnership. Because family limited partnerships generally are taxed as partnerships for income tax purposes, that means that the family partnership is treated as a pass through entity. So any income generated down here by the bank account, rental property, or any other assets has to wind up on the 1040 of the partners at some point. Now, could it lower your tax bill? Yes. If John Doe has given away some of these partnership interests to the family members, then the income that would be allocated to him is going to get allocated to these other family members. If those family members are in a lower income tax bracket, yes, the total tax bill will be lower. But don't forget, the income that should be going to these family members is now not going to John Doe. Is that what you want? Again, for this protection to work, you have to give things away. Giving things away means you're giving it away. That means that the income is going to go to those family members and not the person who set it up. It's not some way of you are giving it to them and then they're secretly giving it back to you. That's going to cause income tax problems, not solutions. You'll also hear, oh, well, now that I've got this business, I can just start deducting things. Sure, you can deduct things that are ordinary and necessary to that business. So, what do you need to deduct to maintain this rental property? The family limited partnership isn't going to change the rules. It doesn't magically become deductible just because it's in a partnership. So don't fall for, oh, well, we can start deducting all of this stuff because it's done through a business or a business like structure. No, you still have to have the ordinary and necessary requirement met. So just because we have dogs, just because my dogs appear on my website as employees, it doesn't mean that because I've got a business structure, I can start deducting the cost of maintenance, uh, healthcare, and vet visits for my dogs. That's not ordinary and necessary to the law firm. That's just kind of ridiculous. So, again, beware of people who say that you can just set up some business and start deducting things. Myth number three, you can lower your future estate tax bill. This is probably the best use of family limited partnerships and what we see a lot. This is going to give you the ability to lower how your estate tax bill is calculated. Again, the key to remember is that you have to give stuff away for this to work. So let's take another look at the structure. When we think about estate tax bills, here for John Doe, he's going to own all of these assets. For estate tax purposes, before we put the structure in here, John would have owned the bank account and the rental property. Once he puts everything in this structure, nothing's really changed. He still owns all of those assets by himself. The way for this to work and the underlying mechanism for estate and gift tax purposes is you're giving away things that have lower value, knowing that they're going to increase in value at a later date. So if we treat this structure as having a total value of $1 million, well, that's because we've got a bank account worth 100,000 and we've got a rental property with my awful handwriting worth 900. Now, if we start breaking this up and we've got these different partnership interests, before John had $1 million here, but once he started giving things away, his value is less. Potentially, you could say it's this, 49.5%, so $495,000 plus another $10,000. So $505,000 of value, while the family members have 49.5%. But the way the valuation works for estate and gift tax, it's not just raw value. You have to look at what the person buying it in a hypothetical transaction would have paid for this, not knowing any other special facts, not having any other special relations to the the seller, in this case, John Doe. So let's assume that somebody just off the street wanted to buy 49.5% partnership interest in this family limited partnership. Well, what are they going to get? They're going to get an entity where they're not in control, they don't have general partnership interest, and they're a minority owner. 49.5%, they're not going to be able to control what goes on. Are you going to pay full value for that? $495,000? Probably not. And the estate and gift tax system recognizes this, saying, look, this is not worth exactly what you would have paid if you had just come in off the street. You may pay something less. And let's just say it's, we're going to discount it 10%. So instead of $495,000, you're just going to pay an approximate value of $450,000. Well, great. Then for estate and gift tax purposes, you've made a gift of something that has a raw value of $495,000, but it's only cost you $450,000. This is how you can save on your estate and gift tax. Okay, this is all well and good, but remember, right now, the estate tax unified credit is $12.06 million in 2022. In 2026, that credit amount is going to drop and be about $6.8 million per person. The good news and the bad news is most of us aren't worried about having that much in assets to justify being worried about estate tax. Really, you've got to start being well north of $10 million before we even start thinking about things like this. But there are a lot of things that we can do that are simpler and easier that we'll want to do before we start layering in structures that may not be effective. So, could it lower your estate and gift tax bill? Yes. Do you actually have an estate and gift tax bill that needs to be lowered? That's the first question you should be asking before you start putting together a family limited partnership that you may not need. So that's myth number 3. It could very well lower your estate and gift tax bill. Let's move on to myth number 4. You can replace those expensive trusts with a family limited partnership. The reality is, no, you probably can't because it's going to do different things in different ways. Now, a trust is a great vehicle that we use so that somebody can have assets owned for them without actually having owned them. What does this mean? Well, a trust separates the beneficial ownership. So the beneficiary gets the benefit of this asset being owned for them without all the burdens of actual ownership. That falls on the trustee. What we can do for this in the estate and gift tax context is that assets that are held in a trust aren't going to be subject to estate and gift tax. Why? The beneficiary, properly structured trust, doesn't own anything that can be counted for estate and gift tax purposes. The trustee does. And the trustee is not liable for the estate and gift tax on it because of the way the system works. But if you try and use the partnership as a substitute for it, you're going to get some different consequences. So when we start looking at our structure that deals with this, if these family members own this partnership interest, well, that $495,000, the $450,000, whatever it is, it's going to be subject to estate and gift tax when that person dies or when they make a gift of that interest later. If it's owned in a trust, you're probably not going to be worried about estate and gift tax for those family members. Another thing to think about is if those family members are under 18, they're not going to be legally allowed to own that asset. This is the way the property system works. Till you're 18, you just legally can't own anything. Why? You're a minor. Instead, you'll need a guardian of the estate of that minor person to own the asset. And once that minor turns 18, the guardianship will terminate. The guardian will have to turn over that asset to the now liberated adult who can then do whatever the heck they want to with it, including taking distributions, selling their partnership asset if they want for nothing, or just taking the distributions and spending it on bubblegum, Maseratis, and cigarettes. Is that what you really want? No. The person you were hoping to protect then has this asset. Not only do they have it, it's also exposed to their creditors. So the partnership structure can do some things that a trust can do, but it's not going to do everything the same way, and it's not going to be able to do everything that a trust does. Similarly, a trust can't do everything that a partnership does. We use different tools for different reasons. We don't want to have these assets exposed to estate and gift tax. We don't want to have them exposed to those family members' creditors. And that's why trying to use a partnership instead of a trust isn't going to get the results you want. Final myth. We want to think about what this will cost. And it's going to cost you something. When you start putting together a family limited partnership, it's not that you just pay your one time registration fee and then you're done. You're going to have ongoing costs to keep this maintained. Think about all the other costs that go along with this. You're going to have accounting costs and annual IRS compliance costs. There will be a tax return for this, and you're going to have to pay for that. Do the assets justify having one more tax return prepared? For all of the partners, they're going to need to get their own Schedule K1 every year so that they can report their share of income tax, loss, gain, and other tax attributes on their own tax returns. Do those family members want to include a partnership asset as part of their tax return? That's going to increase their compliance costs. Beyond that, if somebody's taking an actual salary out of the partnership, well, you're going to need to make sure that you're doing that correctly. So you'll need to have payroll processing in place as well. That payroll processor is going to make sure that the proper amount of income tax and Social Security and Medicare taxes are withheld and paid directly to the IRS. This is a place where you don't want to be wrong. You want to get it right the first time. It pays to have someone else in charge of this. So having a payroll processor like Gusto or ADP in charge of this so you don't have to think about it is a good option. Look, I'm a tax attorney and I don't even want to think about payroll processing. I've never learned it. I've always outsourced it because it's just easier and can be done by somebody who knows better. This is not a place to play. So winding everything together. Yes, family limited partnerships can help you structure and maintain what you own, but they are not some cure all. They do have some costs and they do have a lot of myths surrounding them. Make sure it makes sense for you and your family by discussing this with your advisors before going forward. Thanks so much for watching. If you've got other questions about this, go go ahead and leave a question in the comments below. Also, don't forget to like, comment, and subscribe.